Imagine a town uses your tax dollars to um, repave the playground of a highly exclusive, private, religious school. Your gut reaction is probably, wait, that violates the separation of church and state.
Right, which makes total sense.
But according to the bar exam materials lawyers actually use to master constitutional law, well, your gut is completely wrong.
Yeah, it entirely subverts our everyday expectations. I mean, we all carry around this mental image of a giant, impenetrable brick wall between the government on one side and religion on the other. It feels very absolute. You either cross the line or you don't.
Right. But then you look at how this plays out in everyday life, like at a high school football game, a town hall meeting, or in a state's tax code, and suddenly that giant brick wall looked a lot more like a porous, highly flexible membrane.
Exactly. The reality of how the government and religion interact is incredibly nuanced. The line actively shifts depending on the specific room you're standing in. The rules change based on who is speaking, who is listening, and, well, even the historical context of the town itself.
Which is exactly what we are going to untangle today. Welcome to the deep dive. We have a fascinating stack of sources for this one, mostly rigorous constitutional law prep materials and bar exam study guides.
The heavy stuff, yeah.
Yeah, the exact materials law students spend months memorizing to pass the hardest test of their lives. And our mission today is to decode the First Amendment's Establishment Clause. We're cutting through the dense legal jargon to explore the surprisingly complex ways the state and religion actually interact.
And a quick note before we jump in, we aren't looking at this through a political lens. The prep materials actively avoid that.
Good point.
We are looking strictly at the mechanical legal framework the courts use to evaluate these everyday scenarios. So to set the foundation, the First Amendment contains two religion clauses that are often, well, in tension with one another.
Okay, what are they?
First is the Free Exercise Clause. That protects an individual's personal right to practice their faith without the government interfering.
Got it.
And then there is the Establishment Clause, which restricts the government from supporting, sponsoring, or showing favoritism toward religion. You can think of free exercise as a shield for the individual, and the Establishment Clause as handcuffs on the government.
Okay, let's unpack this. To really understand how those handcuffs work today, you kind of have to look at the old locks that the courts eventually abandoned.
Yes, the infamous Lemon Test.
Right. Because for decades, the absolute gold standard in constitutional law was this Lemon Test, named after a 1971 Supreme Court case, Lemon v. Kurtzman. It was a strict, mechanical, three-part framework used to decide if a government action was unconstitutional.
Exactly. And to survive a legal challenge, the government's action had to have a secular purpose. Its primary effect couldn't advance or inhibit religion.
And here's the tricky part.
Right, it couldn't foster an excessive entanglement between government and religion.
Which I was reading about that excessive entanglement prong in the study guides, and it seems like it created a massive catch-22.
Oh, it absolutely did.
If we think about the Lemon Test, it operates a bit like a school enacting a rigid dress code that bans, distracting clothing. It sounds completely objective on paper.
Sure.
But then a student shows up in a brightly colored sweater, and a vice principal has to decide if it's, like, 10% too bright. Suddenly, the supposedly objective rule creates absurd, contradictory enforcement because human behavior doesn't fit neatly into a three-pronged checklist.
What's fascinating here is how that exact friction plagued the lower courts for years. To give you a practical example of that catch-22, under the Lemon Test, a state might want to provide public funds to a religious school specifically for secular textbooks, like math or science books.
Okay, that seems fine.
Right, but to ensure the school wasn't secretly using that money for religious texts, the state would have to heavily audit the school's finances.
Makes sense. Follow the money.
But if the state audits the religious school too closely, well, it violates the third prong by creating excessive entanglement between the state and the church.
Oh, wow. Wait, really?
Yes. So the government is damned if it audits and damned if it doesn't.
That sounds completely unworkable for a judge trying to make a practical ruling.
Which is why the modern legal doctrine has shifted dramatically away from that mechanical test. The courts realize you cannot apply a rigid math equation to human society. Modern Establishment Clause analysis is far more holistic.
So what do they look at now?
Courts now look at context-heavy themes. Things like historical practices, tradition, coercion, neutrality, and denominational equality. They ask if a government action actually resembles an establishment of religion based on how the country has historically operated.
And this is why this matters so much to you, the listener. The law isn't a simple math equation anymore. It's a deeply contextual analysis of human behavior,
Exactly.
which naturally brings us to the most intensely scrutinized environment in all of constitutional law, where human behavior is arguably the most complex: public schools.
Public schools are the ultimate constitutional battlefield. The core governing principle here is coercion. At its absolute baseline, the Establishment Clause forbids the government from coercing people to participate in a religious exercise.
Right, and direct coercion is obvious, like a state passing a law demanding mandatory church attendance or fining someone for not observing a holiday.
Yes, but in public schools, the courts are hyper-focused on indirect coercion.
I have to push back on that a bit because the study guides lean heavily on the concept of peer pressure. Isn't peer pressure way too subjective to be a strict legal standard?
It sounds like it would be, yeah.
I mean, if a school organizes a graduation prayer and a student feels awkward, is the highest court in the land really measuring the psychological weight of teenage awkwardness? Think about the intense, unspoken social pressure of a high school dance. Everyone is participating, so you feel like you have to. Does constitutional law actually factor in teenage psychology?
It explicitly factors it in. The law views students as a uniquely vulnerable population. The courts acknowledge the stark reality of being a teenager in a restricted environment.
Okay.
Imagine a school organizing a prayer before a Friday night football game. The student isn't just facing vague awkwardness. They are in an environment controlled by administrators who write their college recommendation letters,
Oh, right.
and coaches who control their playing time, plus a massive crowd of their peers. The psychological pressure to stand, bow their head, and conform is immense.
Wow, yeah, the stakes are huge for them.
Exactly. So because the school is using its authority to create that highly coercive, captive audience, government-sponsored prayer in public schools is essentially forbidden.
Okay, so the environment is a pressure cooker, and the state cannot light the fire. But if the school is so heavily restricted, doesn't that create a new problem?
How do you mean?
Well, if a student wants to pray before a math test and the school stops them because they are afraid of the Establishment Clause, haven't they just violated that student's free exercise rights?
They absolutely would have. Students do not shed their constitutional rights at the schoolhouse gate. Private student religious speech is fiercely protected.
Yeah, okay.
A student can pray silently at their desk, read a religious text in the cafeteria, or even organize a Bible study club. The catch is that the school must treat that religious club exactly the same as the chess club or the debate team.
So it's about treating everyone equally.
Right. The dividing line is the difference between government speech and private expression.
A student acting independently is clearly private expression.
Hmm.
But let's apply this to the adults in the building, because this is where the guides get really granular.
They do.
What about a math teacher or a soccer coach? These are adults who are quite literally employed by the state, but they are also private citizens.
Yeah.
Wait, by that logic, could a public school teacher even wear a cross necklace to work? If they are the state, isn't that the state endorsing a religion?
Not at all. A cross necklace is considered passive, private expression. A teacher wearing one isn't coercing a student to participate in anything. The legal test examiners focuses on who is controlling the message and who is actively using the machinery of the state. If a teacher sits in the teacher's lounge during a free period and silently reads a religious book, they're acting as a private citizen. The state is not sponsoring that action.
But if that same teacher stands up at the front of the classroom, bangs an eraser on the chalkboard to get everyone's attention,
And leads a prayer.
yeah, exactly.
Then they have crossed the line. They are taking advantage of their official capacity, the captive audience of the classroom, and the authority granted to them by the state to promote a religious message.
So that becomes government speech.
Yes, that is government speech, and it clearly violates the Establishment Clause.
That makes perfect logical sense when you look at the power dynamic. The state cannot use its authority to pressure a captive audience. But this introduces a massive contradiction that the bar prep materials spend a lot of time untangling. If a high school football coach cannot lead a public prayer because of that power dynamic, how in the world does a mayor get away with opening a town council meeting with a prayer?
It seems wild, doesn't it?
Or a state legislature paying a chaplain to lead a daily invocation? The power dynamic of the state is still right there in the room.
You've zeroed in on the exact friction point that law students spend weeks trying to memorize. On the surface, it looks like two completely different rule books.
It really does.
But this is where the modern doctrine's reliance on history and tradition takes over. The courts have determined that certain long-standing government practices, like legislative prayer, the national motto on currency, or historical displays with religious content are permissible.
Why? Just because they're old?
Essentially, yes. They are viewed as historical acknowledgments of religion's role in society rather than an unconstitutional establishment of a religion.
So is this basically a constitutional grandfather clause? Like if a city has a giant Ten Commandments monument sitting on the courthouse lawn and it's been there long enough, does it just blend into the legal wallpaper? Does it become immune just by surviving for 50 years?
The grandfather clause analogy is helpful, but history doesn't grant a blank check. The courts look obsessively at the context of the display.
So it's not a free pass?
No. If we connect this to the bigger picture, imagine you have a decades-old monument on a state capitol ground, but it's surrounded by 20 other monuments commemorating local history. The court is highly likely to view that as ceremonial. It is part of the historical fabric of the site.
It's an artifact in a museum at that point.
Precisely. But contrast that with a town council that decides tomorrow morning to erect a brand new, massive religious display in the center of the courthouse.
Oh, with the explicit, documented intention of declaring the government's preference for one specific faith.
Exactly. That display is completely vulnerable to being struck down. The court evaluates the location, the primary audience, and whether a reasonable person walking by would see it as a historical acknowledgement or an active, devotional endorsement by the state.
So the grandfather clause only protects the display if the historical context strips away its coercive nature.
Exactly. Context is everything.
Okay, so we've seen how the rules apply to spoken prayers and physical monuments. Let's pivot to the scenario we started the deep dive with, which involves the most sensitive state machinery of all, taxpayer money.
Follow the money.
Here's where it gets really interesting. If the government cannot fund a church, how on earth is it legal for public funds to pay for things at private religious schools?
The rules regarding government aid have evolved significantly. The modern legal stance is that the government is allowed to provide generally available public benefits to religious institutions, as long as it does so on completely neutral terms.
Okay, so if a city provides fire and police protection to a public school, it obviously cannot deny those exact same safety services to a private religious school down the street.
Exactly. And that extends to things like transportation aid for students, or, as in your example earlier, state grants designed specifically to resurface dangerous playgrounds with safer rubber materials.
That's right. The state is making playgrounds safe for children, regardless of whose name is on the front of the school.
Exactly. It's neutral safety.
But those are purely secular physical upgrades. What about the actual tuition? What about a state voucher program? Because paying a student's tuition isn't just fixing a slide. I mean, it is actively funding the core, potentially religious operation of that school.
This is a huge issue, and it's where the bar guides give us a golden equation for the modern era. Neutral criteria plus private choice equals validity.
Okay, break that down for me.
Let's look at the mechanics of a constitutional voucher program. The state does not simply write a massive check and hand it to a religious school. Instead, the state gives a tuition voucher directly to the parents, based on completely neutral criteria.
Like what kind of criteria?
Things like the family's income level, or the fact that their local public school is failing to meet state standards.
I see. So the parent acts as a sort of legal circuit breaker. The state's money flows to the parent, the circuit stops, and then the parent independently decides where to reroute that money.
That is an excellent way to conceptualize it. If the parent takes that voucher and independently chooses to spend it at a religious school, the court views that as perfectly constitutional.
Because the government itself didn't select the religious institution.
Exactly. A private individual made an independent choice in a free market. The state's hands remain entirely clean because the funds only reached the religious school through the genuine, independent volition of a private citizen.
Wow. Okay, so the state has to maintain absolute neutrality with its money.
Mm.
But what happens when the government intentionally abandons neutrality?
What do you mean?
Well, the study guides outline scenarios where the government deliberately bends the rules specifically to help a religious group. That sounds like a direct violation of the Establishment Clause.
It would be, except the Constitution doesn't require the government to be actively hostile toward religion. In fact, the government is fully permitted to lift burdens on religious exercise.
Oh, is this the religious accommodation thing?
Yes. Think about a state prison adjusting its meal schedules and menus to provide specific religious dietary accommodations for inmates. or a state employer granting special leave for an employee to observe the Sabbath.
Okay.
In those cases, the government is intentionally making room for religious practice, and that is considered perfectly legal.
So what does this all mean for everyone else? Because anytime you change a rule to accommodate one person, you risk burdening someone else.
That is the big risk, yes.
Like, if a town accommodates a specific religious group by shutting down all commercial businesses on a certain day of the week, that accommodation becomes a massive financial burden on the business owners who don't share that faith. How does a court decide when lifting a burden for one group crosses the line into actual government favoritism?
The courts draw very distinct red lines here. An accommodation rapidly becomes unconstitutional if it imposes serious, tangible costs on third parties.
Tangible cause, okay.
Right. You cannot accommodate one person's religion if it significantly harms the rights, safety, or livelihoods of others in the community. You also cannot design an accommodation that inherently coerces non-believers into observing the practice.
So a prison offering a kosher meal is fine because it doesn't force the other inmates to eat it, nor does it harm them.
Correct. But beyond third-party harm, there is one absolute unbreakable rule in Establishment Clause jurisprudence: denominational preference.
Which means?
The government can never pick theological winners. It can never favor one specific faith over another. If a state passes a law giving a special tax exemption or a zoning benefit to one specific religious denomination, but actively denies it to others, that triggers what constitutional lawyers call strict scrutiny.
Let's pause on strict scrutiny because that exact phrase appears on almost every page of these bar exam materials.
Yeah.
Just how heavy of a legal burden is that?
It is the constitutional equivalent of a DEFCON 1 alarm.
Oh, wow.
Yeah. When a law triggers strict scrutiny, the normal presumption that a government law is valid completely vanishes. The burden shifts entirely to the government.
To prove what?
They have to prove that their law serves a compelling state interest and is the least restrictive means possible to achieve that interest.
Which I'm guessing is nearly impossible.
And in practice, when a law regarding religion triggers strict scrutiny, it is almost invariably struck down. Declaring an official preferred denomination is the clearest, most blatant violation of the Establishment Clause possible.
So, tracing the path we've taken today, we can really see why that simplistic image of a brick wall just doesn't capture reality.
Oh, it falls completely short.
We've seen how the courts abandoned the rigid mechanics of the lemon test because human behavior is simply too messy for a three-pronged checklist. We've explored how the intense psychological realities of a high school dictate the rules of coercion.
And how the law fiercely protects a student's private speech while restricting a teacher's state authority.
Right. We've looked at the constitutional grandfather clause that protects historical monuments and the circuit breaker logic of voucher programs that rely on neutral private choice. The ultimate takeaway is that this isn't abstract legal theory trapped in a textbook.
Not at all.
Whether you are voting on a local school funding measure, attending a town hall meeting, or just looking at a historical display in your city park, you are watching the Establishment Clause actively working in real time.
It governs the spaces we move through every single day. And looking ahead at how this doctrine is evolving, it leaves us with a profound question to consider.
What's that?
Well, the modern Supreme Court is leaning heavier than ever on history and tradition to decide what types of religious acknowledgments are constitutional. But that immediately begs the question, whose history and whose traditions get to define that baseline?
Oh, that is a fascinating tension.
As the demographics, the cultures, and the varied beliefs of the country continue to naturally evolve over the next century, will a legal test based entirely on the traditions of the past be able to fairly govern the society of the future?
Right, because when you rely on history to draw the line between church and state, you might find that the wall isn't just a shifting membrane. It was built by a specific group of architects for a specific era.
Exactly. And whether that historical foundation can hold up the realities of tomorrow, well, that is something we will all have to watch unfold together.